To dismiss.
To dismiss. Sorry, Your Honor. That's correct. Frankly put, it is our position that the law is clear and the state has stipulated that jeopardy did attach on that original indictment, and that jeopardy is continuing at this point in time as we're before this court today. That is in their response to our motion to dismiss the superseding indictment. So it's not a question to this court whether jeopardy attached if jeopardy is continued. We know it attached, we know it's continuing. The question lies, can the state seek and receive a superseding indictment while jeopardy has attached and is continuing to be attached on an original indictment? And our position is that they cannot seek a superseding indictment. I think Willard v. Stewart, State v. Johnson, State v. Henry, I think those cases are clear that the state cannot do this. As a matter of fact, one of the cases, Williams v. Stewart, puts it, the state may obtain a superseding indictment, which is an indictment obtained while another indictment is still pending, if jeopardy has not attached on the first indictment. That's 2012 case. Rule 7 was simply put into place for this reason. It was put into place so that the state could not seek or amend indictments without the consent of the defendant or with the defendant's consent if they were to do that. And Rule 7, Part 2 says the court may, without the defendant's consent, and before jeopardy attaches. So for the state to seek a superseding indictment after jeopardy has attached, frankly, cannot be done. Judge, they have cited to a case of State v. Blair, which cites to a case of State v. Volkovich. And just to point out some differences in those cases, both of those cases deal with a Rule 8 joinder issue. Both of those cases are complex in terms of their procedural history. As a matter of fact, in State v. Blair, if the court will indulge me for a period of time here, in 2007, there was an original indictment in State v. Blair. This is Chattanooga case. That original indictment was case number M07003. There was 3 counts of a conspiracy to commit first-degree murder and 1 count of perjury. That was in 2007. In May of 2008, the state agreed to nolly the 3 counts of conspiracy to commit first-degree murder, which left pending the perjury case out of that particular case. In March of 2008, prior to that, the state, and this is prior to trial, had indicted in case number M08125 another conspiracy to commit first-degree murder and conspiracy to commit aggravated robbery. The court at some point in time dismissed the robbery case because the statute of limitations had run on that particular case. After that happened, it left with the court in case number M07003 1 count of perjury and a count of conspiracy to commit murder. That was M08125. So we have 2 cases at that point in time. This is the State v. Blair case that the state of Tennessee has cited. In October of 2008, the grand jury returned another indictment. That indictment bears case number M08455. And in that particular indictment, the defendant was charged with conspiracy to commit especially aggravated robbery, and 3 counts of felony murder. That's what they went to trial on. That's the case of Tawana Blair. The court had asked from Blair's attorneys and the state which case they were prosecuting first, and they chose the 455 case, which was the felony murder, which left the perjury and the conspiracy to commit first-degree murder lingering. A mistrial was declared in case 455, which left those 2 other cases. And the case was clear that case numbers 125 should have been joined with 455 under the Rule 8 And nowhere in Blair does it talk about a superseding indictment from the original indictment. The Blair case specifically states that the conspiracy to commit first-degree murder was never tried and a mistrial declared in that case. That is not the facts in the Tawana Blair case. The state argued on appeal that the conspiracy charge that Jeopardy had attached, and if it had not attached, it was still ongoing. The court ruled it had not attached because it literally was not tried. The court had inquired whether the state was going to try that case. They chose not to try that case. They chose to proceed to trial on a different case. Jeopardy did not attach. What kicked that case out, why that case was dismissed, was because the state had failed to join it under mandatory Rule 8. So to cite Blair in response to our motion to dismiss superseding indictment, it's just uniquely distinguishable from the facts in this case. The conspiracy to commit first-degree murder was never tried. There was never a mistrial declared on that. That was the issue before Blair. And the court ruled that is in fact the case, but rather than that, it should have been joined, and because it wasn't joined with case number 455, they dismissed that case. Another case that Blair cites to is the case of State v. Volkovich. Hope I pronounced that right. And that's an interesting case in that there are several indictments going back and forth. There was an original indictment to conspiracy to sell marijuana. There was some changes in the law. There was another indictment that charged them with delivery, and then another count of delivery. There were some counts of money laundering. What Volkovich talks about, and again, this is a Rule 8 joinder issue. These are the cases that the state are citing, was that the Volkovich court, in allowing them to issue a superseding indictment, there was testimony from the first trial that gave rise to new charges. Those were the new charges. The charges that they proceeded to trial on had never been tried. Jeopardy had never attached. It was from that trial that an individual that was on the witness stand gave information that allowed the state to go back and seek a superseding indictment based on that new information. The court said, yeah, you can do that, but you can't go and obtain a superseding indictment without any additional information. If this court, if the state would have discovered some evidence at trial, at this first trial, that they didn't know about, that's key, that they didn't know about, and then they go and obtain a superseding indictment, sure they can do that based on that new information. They know the same information today that they've known since this case has been birthed, since the investigation of this case. They have sought a superseding indictment. The superseding indictment under the case law that I have cited simply cannot be. To elaborate further, in State v. Harris, the court eloquently put it, the power to seek a superseding indictment lies within the broad discretion of the state. A superseding indictment is an indictment obtained without the dismissal of a prior indictment. We don't have a dismissal here of any prior indictment. Where there has been no jeopardy on the first indictment, a grand jury may return a new indictment against an accused. It's clear. The state cannot seek a superseding indictment and obtain a superseding indictment based on information they know, not based on new information, and prosecute that indictment after jeopardy has attached. We'd ask the court to dismiss the superseding indictment. Thank you.
All right, Mr. Robinson, you have anything to add?
No, Your Honor. We gave our notice of intent to adopt any motions of the co-defendant, and I think rely on the argument of Mr. Bowling.
All right, the state's response.
Please, court, counsel. The state has filed a written response to the motion and certainly rely on that, as well as
the language in Blair, which I submit stands for what the law is in the state of Tennessee, and that is that as far as indictments are concerned, Tennessee is essentially a clean slate state, that where the defendants are placed back in the same position they were prior to the first trial, then superseding indictments are allowable. That is the language beginning at the bottom of page 12 of the Blair opinion, which I trust we did provide the court a copy of that. It was not one cited by counsel, but it was an opinion from the Court of Criminal Appeals, July 9th, 2015, very timely. Submit where that bottom paragraph where the state was appealing, and yes, I'm not going to disagree with what the facts were in Blair because they were a little different, but when we get to what the law is, the court says that we don't have to decide about Fowler, Vukovic, Hilliard, so on and so on, because in each of those cases, a mistrial was declared as to all counts. That is exactly what we have in this case. And whether we phrase it motion for new trial granted or a mistrial, the result is the same. And I know we did have some discussion about what to call it, but it really doesn't matter. It was on motion of defense counsel based on the juror number 9 misconduct that they were restored to the same position that they were prior to trial, which, as the court on page 13 of the Blair makes note, there was never a final disposition of any of the charges, making a new trial on all the charges necessary. Exactly what we have here, based upon the court on defense motion granting a new trial. The mistrial restored, I'm quoting this, the mistrial restored the defendant to the same position as he was in before trial when additional indictments are permitted, and the defendant was not required to endure separate trials for the same criminal episode. This will be a retrial, not separate trials, not piecemeal, not the holding back that Rule 8 was designed to prohibit. The cases where we see where the state is not allowed to seek superseding indictment generally fall into those two categories. Where there's a violation of Rule 8, the mandatory joinder of offenses, which we do not have here. And I would note that the superseding indictment in this case tracks the jury verdict, essentially, and the election of offenses to the letter. And those situations where the state runs afoul of re-indicting, where it can be accused of vindictive prosecution. Those are generally the two areas where look back at it and say, oh, no, the state was holding back, there were no new facts, so it's a violation of Rule 8, or the state having apparently felt the need to add additional charges based upon the defendant successfully obtaining a new trial, the vindictive prosecution. We do not have that here. If anything, as Your Honor well knows, looking at the indictment, this indictment reduced the charges against Mr. Vandenburg. So the bottom line is, of course, the pretrial rulings are the same. We don't wipe those away. But as far as counsel could have waived the issue of the juror misconduct, and I'm just talking in theory because obviously no one would do that given what we found out, but hypothetically that issue could have been waived. We could have gone up on the original, their assertion about the original indictment, and let the case be decided on that. Your Honor certainly ruled, we had various hearings about that, and the court, we think, correctly ruled that the indictment provided notice as to what the defendants were charged with, along with the bill in particular, and so that indictment was valid. That indictment is back to square one based upon counsel having obtained a new trial. It is a clean slate with respect to the indictment. That is what the Blair case, and again, the specifics of the Blair holding are not so important to submit as the restatement of the law, and it is exactly, that law is exactly what we have here. The mistrial restored these defendants to the same position they were prior to the jury being sworn, and additional indictments, superseding indictments, are permitted. I think that is the black letter law. We would rely upon the written response and basically the Blair case for what it stands for, of the general proposition that Tennessee allows superseding indictments when the defense is sought and obtained a new trial. Thank you.
All right, thank you both. Thank all three of you for that matter.
You want to briefly, could I just
Yes, you may. Your motion.
respond? There's a reason why maybe the factual procedural history of Blair may not be important to the state, and that is because there was never a trial and a mistrial declared on the charge in which they sought to prosecute. The Blair court, they had tried a series of cases before let me back up, before the trial began on the conspiracy to commit first-degree murder, the felony murder case, and the perjury cases. The court asked the state, elect what you're going to try. Let me know. It's not in the record, but at some point in time, the state moved forward on all the charges except for the conspiracy to commit first-degree murder. And when a mistrial was declared on all those other charges, and the court actually declared a mistrial on the lesser included offenses, did the state try to come back and then prosecute and subsequently indict the conspiracy to commit murder with more counts? It's a 2012 CR case. There was never a trial. That's why it's important. It's distinguishable. There was never a trial on the conspiracy to commit first-degree murder. It's there. Now you had to break it. I had to break it down. I spent hours breaking that case down, like the Vokelich case. There's just so many indictments that state it's trying to prosecute individuals under, but there was never a trial. And it is factually impossible to be put back to the position that we were prior to trial. Jeopardy attached. To say that we're in the same position, no, we're not. Jeopardy has attached on the indictment in which we went to trial on. To say we're in the same position as we were before we picked a jury, no, we're not. Jeopardy attaches after we pick a jury, after a jury's sworn in. We are not a clean slate state. There is no case that says we're a clean slate state. As a matter of fact, it is clear in State v. Johnson, arguably, this continuing of jeopardy means that for purposes of utilizing a superseding indictment, the tardy bell had already rung when jeopardy attached in the first trial. That's page 14 of our memorandum in support of our motion to dismiss. We are not back, I think General Moore put, square one. We are not at square one. A jury was sworn, jeopardy has attached. We cannot be put, it's factually impossible to be put back in the position we were before trial commenced. It can't happen, which is why these cases say what they say. After jeopardy has attached, you cannot get a superseding indictment absent some information that brings about other charges that they didn't know about, that they now know about, transpires. That's not the case here, Your Honor.
Thank you again. In this particular case, there are no new charges that have been brought with the superseding indictment, only an additional element. I thought through this matter quite a bit, And it really, in the court's mind, places the defendants back in the same position that they were initially. And as such, I do believe that the superseding indictment can be brought. And I will respectfully deny the motion to dismiss. I suppose that the parties would like a written order to that effect for the record, and the court would be happy to provide that. All right? Okay, now we can proceed with the motion to sever, I believe, is the next matter.
Yes, Your Honor, please, on behalf of Mr. Vandenburg, Your Honor, please. Give me 1 second, please, Your Honor. Your Honor, please, in respect to Mr. Vandenberg's motion to sever his trial from that of Mr. Batey's trial, and relying on a memorandum as well as our motion for this severance and our memorandum in support, I believe the facts reveal that these cases should be severed. There are communications that occurred by text message, by digital media, that have occurred by Mr. Batey, also, not arguing for Mr. Batey, but also of the defendant, Mr. Vandenburg. At least 2 statements that Mr. Batey gave. I'm not here to talk about Mr. Batey, I'm not here to belittle Mr. Batey, but there's at least 2 statements that were given. One was given during trial when Mr. Batey took the witness stand. The other statement was made after trial when Mr. Batey conducted an interview with Dr. Field. There were statements made by Mr. Batey prior to trial in both oral form as well as digital forms of text messages, communications to Mr. McKenzie. The severance of these 2 defendants, Mr. Vandenburg and Mr. Batey, is imperative to assure a fair and just trial with due process of law. Your Honor, please. This, the statements that have been made by Mr. Batey, and the court's well aware that the case law, should Mr. Batey take the witness stand and should we be able to cross-examine Mr. Batey, then the court may not be in a position to sever those trials. We don't know the answer to that yet. We don't know if Mr. Batey is going to take the witness stand. Mr. Batey doesn't know if Mr. Vandenberg is going to take the witness stand. But it is implied in this case, whatever Mr. Batey did, Mr. Vandenberg is criminally responsible for. That's the state's theory. So when, as the Cruz Court said it, ordinarily a witness is considered to be a witness against a defendant for purposes of the Confrontation Clause if his testimony is part of the body of evidence that the jury may consider in assessing his guilt. The state, in their response, says that Mr. Batey's statements are not prejudicial to Mr. Vandenburg. That's not the law. What the law says is if their statements are a total evidence of the body that is going to be given to the jury, then they are considered a witness against the defendant. And that state, that's the Cruz Court. Your Honor, please. Further speaking, they say in Cruz v. New York, United States Supreme Court, where 2 or more defendants are tried jointly, therefore the statements of one of them that implicates the others is not admissible against the others unless the defendant making the statement waives his Fifth Amendment right and takes the stand. So Mr. Batey's statements they do not have to be prejudicial against Mr. Vandenburg. The theory puts them prejudicial against Mr. Vandenburg. The theory of principal responsibility, if Mr. Batey did this, then Mr. Vandenburg is responsible, places that implied prejudice there. And even if they weren't prosecuting under the theory of criminal responsibility, the case law is clear that if it is considered in the total body of evidence that the jury is to consider, then these cases have to be tried separately. The evidence is such that an individual is alleged to have penetrated a victim, and Mr. Vandenburg is being prosecuted as being criminally responsible for that aggravated rape. Criminally responsible. So any evidence that is considered with a co-defendant that portrays that clearly is barred by case law and authority. So we would ask this court to sever these defendants as it relates to the upcoming trial date, Your Honor, please.
Well, you want to go ahead and respond now?
Yes.
All right.
Because I don't believe that was the law. If it was, and we know you never have to go on
trial. I think the law is clear, Bruton, and all this protege that it must implicate the other defendant for it to be prejudicial, require severance. The court's already heard the Batey motion for severance where this is argued. Mr. Batey actually had a legitimate issue for severance because Mr. Vandenburg had given a statement to the police implicating Mr. Batey. He'd also participated in a phone call where he left a message using the word they, if the court can remember. That the state decided not to use Mr. Vandenburg's statement in our case in chief, and we redacted that tape so that there would be no implication of guilt by Mr. Vandenburg to Mr. Batey. So the court allowed a joint trial and heard the joint trial, and I don't think there's any issue raised at all that required a severance. I'm not aware of any statement Mr. Batey has ever made that implicates Mr. Vandenburg. He told Vanderbilt nothing happened. He told the police nothing happened. He took the stand and said he didn't remember what happened. And I haven't reviewed Dr. Phil's statement, but I think the only thing I can recall he said was Mr. Vandenburg was a good guy. The bottom line is he's never given a statement implicating Mr. Vandenburg. And again, the state's not going to use his statements to Vanderbilt or the police or Dr. Phil in our case in chief. So if he takes a stand, obviously there's no issue. He can be cross-examined about any statement he made. So there's not any type of issue requiring severance. The state's not going to introduce these statements. He didn't argue disparity of the evidence, which is cited in his motion, but I think it's clear. The state has cited the Howell case. There's also State versus Mickens, 123 Southwest 3rd, 355, 2003 case. Both those Tennessee cases say disparity of the evidence is not sufficient. They cite a federal case. There's numerous federal cases stating the same thing. U.S. versus Fields is 763 Federal 2nd 443, which is a 2014 case out of 6th Circuit. Also U.S. versus Driver 535 Federal 3rd 424 208, which is a 6th Circuit case also saying disparity of the evidence is not sufficient alone for a severance. And even if it was, to argue that there's a disparity of the evidence in this case, that it's much greater against Mr. Batey, I think is disingenuous. As the court has heard the evidence in this case, it's overwhelming against both defendants. They're on video committing the crime. Mr. Vandenburg's on surveillance video doing all various types of things. His voice is on the video. His voice is on phone calls. His text messages back and forth is destructive of the evidence. His computer showing the porno, the testimony of his own roommate, Mr. McKenzie. I mean, the evidence is overwhelming, so there's no disparity of evidence in this particular case, and there's no legal basis for severance.
Well, I should allow voting.
If he has any particular. Mr. Ray. All right.
I want to make sure I understood that Mr. Thurman's statement. I heard him say that he was not going to use any of the statements. Were we referring to the Dr. Phil interview, or were we referring to the trial testimony, or both?
We're referring to all of those, Your Honor, please.
All right.
Trial testimony, Dr. Fields' statement, the Vanderbilt statement to the police.
You're not going to use any of Mr. Batey's statements?
Not in the case of Chief. If he takes a stand, we'll use all of them.
Judge, there are other statements made by Mr. Batey that in particular one to Mr. McKenzie, and it is particularly important in this case because Mr. Vandenburg, again, is being charged with being criminally responsible for the actions of Mr. Batey. Mr. McKenzie tells us that he talked with Batey after this incident and asked Mr. Batey if he had penetrated the victim. And Mr. McKenzie said that Mr. Batey told him, yes, I did penetrate her. If Mr. Vandenburg were not being charged as being criminally responsible for that particular act, that would not implicate Mr. Vandenburg. But that's not the situation that we have here. Mr. Vandenburg is charged with being criminally responsible for that particular act, and any statement by Mr. Batey about that particular act establishes at least one element of the offense against Mr. Vandenburg. So that does implicate Mr. Vandenburg, that particular statement there, and the record is full of those types of statements by Mr. Batey to others talking about the offense. With regard to and this is on page 6 of our memorandum, paragraph 17, where a severance of the trial should be granted where a joint trial could prejudice the moving defendant to the extent that due process or a fair trial are impaired. My understanding of the state's theory is that part of their theory is that Mr. Vandenburg was the ringleader in this case. He is the one that set all this in motion. He was the leader. He was the one that got everything going and kept it going. Our theory is that Mr. Vandenburg did not know Mr. Batey, Mr. McKenzie, or Mr. Banks prior to this night in question, and that's the testimony from McKenzie, Banks, and Batey, and that there was a particular incident the night before that allegedly occurred, which involved another case of sexual misconduct in which Mr. Batey and Mr. McKenzie and Mr. Banks were allegedly involved. We submit that would be part of our theory.
That, Your Honor, please, I don't think there's anything in the record about any sexual misconduct.
Right, we've gone over
Been through that. It's not supposed to be said in open court.
Right, well, I agree with you. I'm going to sustain that objection. We've gone over that issue before, and there were no allegations that I'm aware of.
Your Honor, on Mr. Batey's part, I just object to the term misconduct in that type of statement. Whether it's the court allows Mr. Reagan to bring that up or not bring that up, I just object to the term misconduct because I don't believe that determination was made.
Well, what he said was alleged, but again, that's something we need to go into at this juncture. All right?
And I understand, Your Honor, but this argument that we are having here right now is a microcosm of what I'm trying to talk about, is that our ability to present a defense, our right to present a defense, is impaired by being at trial with Mr. Batey, because Mr. Batey has rights also, that certain prejudicial evidence not be admitted against him. And if we go to a joint trial, we can't put in the evidence that we need to put in to establish our defense if Mr. Batey is objecting to it, because he has rights also. And that argument that we just had, this particular little illustrates what I'm talking about, is that our right to present a defense, our ability to present a defense, is being impaired by going to a joint trial. And what we are talking about with regard to the weight of the evidence, if you will look at the state's final argument in when they're talking about the criminal responsibility, they are talking basically that Mr. Vandenburg did not physically do any of the acts. And they talk about him making statements and taking this photograph and making some statements of supposedly, the state's theory, I suppose, would be that he was encouraging something of this act. But that was what they rested their theory of criminal responsibility on in their final argument. There is a vast difference between the weight of the evidence against Mr. Batey as far as these actual acts, actual alleged acts, than there is against Mr. Vandenburg. And we submit that there is a great danger of prejudicial spillover effect if we are forced to go to trial, a joint trial with Mr. Batey. Thank you.
I would just say that one statement is not implicating Mr. Vandenburg in any way.
Batey says he penetrated. He doesn't say Mr. Vandenburg was there. Doesn't say Mr. Vandenburg encouraged him to do it. He doesn't say a thing about Mr. Vandenburg. Like I say, you could never have a joint trial if that was the law. I think clearly the state has taken a position that any statements that would implicate co-defendants are not going to be put in our case in chief by the co-defendants. I think it's kind of interesting that the state offered, once Mr. Robinson injured his arm and the state was ready to go to trial, we offered a severance to defendant Vandenburg, and he strongly declined it and argued that absolutely he didn't want a severance, and that the case had to be tried together. And he's already been offered a severance in this particular case at that particular time because of the injury to Mr. Robinson. We were still had all of our witnesses from out of state and everything. We were ready to go to trial. We said, we'll go ahead and give you a trial. And he declined that at the time. He's not legally entitled to a severance, and he's, I guess, waived the issue anyway.
May I respond to close our motion?
Well, you get the final word, it's your motion.
Thank you, Your Honor. Judge, we're in a vastly different position now than we were at that point in time. And of course, Mr. Boland and I were not representing Mr. Vandenburg at that time. And I'm not fully aware of what happened at that particular case, but we are in a much different position at this time. The state's theory of criminal responsibility in this state is clear at this point in time. And the state is saying that this statement by Mr. Batey to Mr. McKenzie does not implicate Mr. Vandenburg. Well, by the state's very theory of criminal responsibility, it implicates Mr. Vandenburg, because Mr. Batey is admitting within that statement to the offense. And that gets the state halfway to Mr. Vandenberg's criminal liability. That essentially is saying that, yeah, this offense occurred and it implicates Mr. Vandenburg, and that's what Bruton talks about when you have two defendants. He doesn't say anything about Mr. Vandenburg, but it's going to be very clear to the jury under the state's theory that that's what he's talking about. He's talking about that act that Mr. Vandenburg is criminally responsible for. Thank you.
Now, Mr. Roberts.
Your Honor, I don't know if this would be considered a new motion to sever or if this would be considered a renewal of our motion to sever at this time. And while similar to the last time, I believe the experience of the last trial gives even more pause and cause for concern that a severance is appropriate in this case under Rule 14 of the Tennessee Rules of Criminal Procedure. Your Honor, this court is determining if it's appropriate to grant a motion for severance, and that occurs when it's to promote a fair determination of the defendant's guilt or innocence. Your Honor, in this case, while my biggest concerns, Your Honor, again, and I outlined those last time, and I think, again, it gives pause and cause for concern because they are introduced. If Mr. Batey chooses to testify again, then statements concerning the recorded telephone call that Mr. Vandenburg made with the assistance of the police department to Mr. Batey and making suggestions to him and attempting to implicate Mr. Batey through that phone call. And those would certainly be questions, if Mr. Batey testifies, that's going to come up. And with that, Your Honor, It's just a concern about, once we start the trial, I feel like a judge would tend to be more conservative in if a motion for severance during the trial was appropriate. We have to anticipate all of these things, Judge, and I think that the telephone call coming in can happen. It was introduced, the controlled call was introduced last time, Your Honor, and those statements being used to suggest and implicate Mr. Batey, and then we don't get a chance to question Mr. Vandenburg on that. It's a serious, brutal issue, Your Honor, and I think based on this, based on the statements from Mr. Thurman today, and based on the state, regardless, they're going to use text from between Mr. Batey and Mr. Vandenburg if Mr. Batey takes a stand. And again, I don't get the confrontation right guaranteed to Mr. Vandenburg. I can subpoena Mr. Vandenburg to the trial, but I can't make him testify. But the state's being allowed to introduce these text message exchanges between Mr. Vandenburg and Mr. Batey, and the state takes those text messages and then they spin it and twist it and argue to the jury that it is implicating. That's what they argue. So if they're going to be introduced, the weight, the gravity of the weight of prejudice to Mr. Batey in those circumstances is extreme, Your Honor. And so for purposes of today, whether this motion is a new motion or a new renewal, I think the court can take into consideration what occurred at the last trial, and the court can take into consideration the text, the recorded call, and how all those were used to implicate Mr. Batey without the right to confrontation, and therefore we believe these parties should be severed.
Well, please, I don't believe having concern is enough to grant severance as part of this victim act.
Go through 2 more trials, case,
Having a state
go to the extreme court of time consumption required for 2 trials. A phone call made by Mr. Vandenburg and Mr. Batey, that was not introduced in the trial. If Mr. Batey tried separately, it was really good. No problem. Please put that in a second. Sure. Implicating Mr. Batey. The statements of text messages were allowed by the court as part of co-conspirator statements further to the conspiracy where they're attempting to cover up this matter, which would be admissible either way. So he had cited nothing that would be admissible. I think we're not going to put that phone call in, Batey, in our case. So we'll just have to see how it goes. We did put it in the other trials, as he said. So I don't think there's anything. You've already denied his motion. There's no legal basis for a motion for Mr. Batey to have a severance.
Any final response? No. All right. Well, as the state is stated today, they don't intend to use the statements that implicate the other, unless, of course, either one chooses to testify. And if they, of course, went to trial separately, then there are a lot of issues that would be raised by the state. So I just don't think that a severance is appropriate at this time. I clearly understand your arguments, but I'm not inclined to grant a severance at this stage. So that's going to be respectful.
Your Honor, please come out very far from the court. I just don't want to get into a shin-kicking contest with the definition of implicate. So could we ask the state to, they say they're not going to introduce any statements Mr. Batey made that implicates Mr. Vandenburg, and the court has demonstrated that and represented that. But we don't want to be at the 11th hour in court and they say, oh, well, that doesn't implicate him, and we get in this shin-kicking contest of, oh, whether it does or not. So can we have the state, if they plan on introducing any statements of Mr. Batey that say they, we, us, that would implicate Mr. Vandenburg, that we be put on notice and be able to raise those pre-trial, Judge?
Well, I think you, in essence, been given notice this morning. To be able to predict what may possibly happen, I don't know if we can do that. I mean, if an issue comes up at trial, we can deal with it at trial. I mean, the state wants to respond.
I think we were very careful the first trial, Your Honor. We brought attention to the tape, and Your Honor allowed us to redact the we out where Mr. Vandenburg was talking on the phone about urination. And we took the we out so it wouldn't indicate Mr. Batey. Do the same. I don't know of any of those statements. Of course, I don't have automatic recall of everything that was ever said in the trial, but I don't recall any of those. So we're very aware of Bruton and the issues it raises, and we'll constantly try to keep abreast of those. But I think implicates pretty clear. And like I said, I don't know of any statement Mr. Batey has ever said Mr. Vandenburg did anything.
All right. Well, before we move on, we're going to take about a 10-minute break and then we'll go from there. All right.
All rise. Motion recess for 10 minutes.